We will go on the record in the matter 17 CF 172, State of Wisconsin versus Nicole Simmons. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Ms. Simmons in person with counsel in custody with counsel Eugene Harrington. We're set today in this matter for sentencing hearing on revocation. Ms. Simmons pled guilty on March 14th, 2019. She has now since been revoked. The court has reviewed the revocation order and warrant packet. Victims' rights compliance, Mr. Schmidt.
Yes.
All right, victim is present and here.
Would like to make a statement.
And victim would like to make a statement. All right, victim can come sit up here on the black desk. Can either state the name for the record or initials, and then may provide this statement.
My name is Teresa Ekstrom, and I wish to make a statement in the matter of Nicole stealing my vehicle. We were good friends at one time, and she babysat for my children when they were small, and then when she had children, we babysat for her, and she lived with us for a time. She worked during those times at various jobs. She decided to borrow my car without my permission. She just came into the house late at night. It was after 9:30 at night. She came into the house. She told my husband that I had given her permission to use my car when I had not. And I had gone to bed, so I had no idea where my car was. I just know that I got up the next morning and it was gone, and I reported it stolen. She was ordered to pay restitution. She has not paid 1 penny of restitution. I feel as though she feels she doesn't owe me anything when even though you ordered it, she hasn't paid any restitution. And it's just been a real struggle to get by from day to day. Some days are worse than others. But I believe that a person should pay their bills. And if they do something wrong, I believe they should pay for it. And I believe Nicole should pay for stealing my car.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation.
Before that, I've received the packet. I have no corrections.
Oh, yeah. Okay. Have you received the packet?
I have no correction.
Okay. DOC recommends 6 to 9 months. 9 months is the max. I'm going to be recommending the max of 9 months jail. But my calculation, her sentence credit is 98 days if you include today as the end date using the packet. That's January 2nd to today. When I read the packet initially, I kind of stopped halfway because I realized, why is a 2017 case coming back for revocation in 2024, 7 years later? And what really struck me, and where I think the court's starting point in this case should be the victim's statement, not just today, but back at sentencing. The victim impact statement that she wrote back then was very clear. She didn't want probation. She wanted jail. The victim complained that at the time Nicole stole her car, she was already currently on probation for stealing her debit card. The victim wrote, quote, "I feel that Nikki won't learn unless she has to pay by losing her freedom," end quote. The state made a different plea agreement back then. I think we can conclusively say now that the state was wrong. We should have done jail back then. I think the victim was right. Regardless, the court followed the plea agreement back then and ordered Nicole on probation on March 14th, 2019. So the case took like 2 years to resolve and then she was sentenced to probation. According to CCAP notes, what the court ordered was to pay back the $3,500. The court ordered $300 a month. The packet indicates that the defendant absconded within a month of going on probation and has been absconding for 5 years. She was using methamphetamine, consuming alcohol, and committed countless thefts and lied to the police about her name. I think I can say that because the packet indicates that those crimes have actually gone to completion. She's been convicted of them over in Minnesota. That also means she's paid $0 of restitution in this case. When I checked CCAP, I saw the debit card case. She still owes money on that as well, which leads me to believe it's not very likely she's going to pay back money to the victim in these cases. That also effectively means that after pleading guilty with a plea deal that she agreed to do probation and pay restitution, she essentially immediately changed her mind, if it wasn't her intention from the outset, to basically refuse probation and just kind of take a 5-year rain check on punishment without the court's permission. I find it reprehensible that while she was supposed to be on probation with us, while people are supposed to have the comfort of knowing DOC was watching her, instead she was in Minnesota, where she was charged and convicted of robbery, shoplifting, dishonored checks, theft, and 2 counts of giving false name to the police. And so I find that deeply concerning because it tells us a lot about her I guess you'd call it performance on probation is how the court would factor it in, even though she effectively didn't participate in probation, that she was going to continue this behavior, that she was never going to pay the restitution, that she was never going to participate in the DOC functions that would have enabled perhaps some shot of rehabilitation. I think it shows she had no intention of rehabilitation. Judge, I think given these aggravated circumstances, 9 months jail is appropriate. I think the victim, I think Ms. Ekstrom, she was right back in 2019 at sentencing, and she's right today. I think probation was completely ineffective in every way, which is what we've learned now. I think jail's necessary now. I think that had the court sentenced her in 2019 to a jail sentence, knowing, she's never going to pay restitution, the aggravating circumstance of being on probation for theft against the same victim on the same time as sentencing and when that offense occurred, I think the court would have done something like a 9-month sentence back then. So for those reasons, I would ask for the court to also view this as aggravating and do 9 months instead of something lower. Thank you.
Thank you. Mr. Harrington.
Let's tone on the 3 factors: gravity of the offense, character and rehabilitative needs of the defendant, need to protect the public. She's convicted of a Class A misdemeanor, $10,000, 9 months. The crime is aggravated by the victim's statement that it was a product, the plea was a product of an agreement that the state agreed to, and as did Ms. Simmons. But there's a significant impact upon the victim, so the court, I'm sure, will consider that. Character and rehabilitative needs of the defendant. She's 36 years of age. She has 5 children. She's an addict. Substance abuse, addiction is not a offense to any crimes. We know that. These folks generally know that. But it's not, it aggravates the criminal behavior, could be considered as an aggravating circumstance, but it also could be considered a mitigating circumstance, because oftentimes people that are addicted go from one drink to the next, or one dosage of methamphetamine to the next. And I think that's really what Nicole has been doing for these years. Mr. Schmidt characterized it as no intention at rehabilitation. Addicts don't often form intent to do certain things. They more appropriately probably just respond to the urges and the cravings that they have for their substance. When I spoke with Nicole the other day, we talked about her education and treatment and all those sort of things. She's a 2006 graduate of the Grantsburg High School. She has an associate's degree in business management from WITC. She's diagnosed with PTSD from abusive relationships. She has been in treatment once, twice. She is currently on probation in the state of Minnesota and is awaiting, once Wisconsin cases are done and resolved, she's eligible for a treatment program in Hutchinson, Minnesota. It's called Integration. It's a dual diagnosis treatment facility for mental health and substance abuse issues. It's a 75% success rate over the course of 2 years. Her agent in Minnesota is working on that. Nicole, Mr. Smith's correct. The report shows Nicole has engaged in significant criminal behavior since she was placed on probation. She's been convicted, I think it's 6 times since she was last before the court. Simple robbery, theft, shoplifting, false names a couple times, dishonor check, take transfer, movable property without consent. You know, she's engaged in criminal behavior. All the while, she's been addicted to substances and those sort of things. I asked Nicole the other day, tell me what is good about Nicole Simmons. And I wrote it down and I put quotation marks around it. When sober, I'm a good mom. When sober, I'm a hard worker. She was the manager at the Siren Subway facility for some 11 years, from 2002 to approximately 2015. She had worked there, but she was a manager there for a while. And her recognition now of her good characteristics are conditioned upon when sober. That's, I think, an important realization by her. She is diagnosed with ADHD, or not ADHD, PTSD, acid reflux, depression, anxiety, and she's taking medications for all those. Recently, she gained, she told me this, 8 pounds in just a couple days. She has fluid buildup. I told her to bring her blood pressure record form that she's been keeping in the jail. Her blood pressure generally is elevated. She came here, it was 104/78. This morning it was 141/95. They're going to get her some medication, a water pill, to get rid of some of the fluid that's being built up in her legs and presumably in her cavity, chest cavity as well. Wheat suggests that the court sentence her to 6 months, which is certainly the low range of the Department of Corrections. With respect to the credit for time served, Nicole was arrested October 4th, 2023 in Olmsted County. All of her Minnesota cases were completed and placed in probation, as the packet reflects, by November 7th. She's been in custody on the Burnett County warrants since November 7th. And November 7th to today is 153 days. We would submit that the law entitles her to credit for that. Mr. Schmidt, when you calculate from January 2nd to today, is My calculation was 97, and Mr. Schmidt came up with 98, and that's whether you count the first day and the last day, but I would submit that 6 months with 153 days credit is appropriate. She needs rehabilitation. You knew that in 2017. She needs treatment. She's made some effort to do that. The court can ensure her sobriety by keeping her upstairs. When society gets done with the enforced sobriety of jail, there needs to be a plan, or that those cravings and feelings of addiction will come back up, and she will be a problem for society again. Enter a judgment, money judgment for the restitution. I think I haven't done bankruptcy in 30 years, but I think judgments based upon criminal behavior are not dischargeable. So it's just a matter of time when Nicole's gonna have to address that money that she owes. And that's the solution. With that, I'd urge the court to sentence her to 6 months and 153 days credit. Thank you, Judge.
What about the 30 hours of community service the court ordered back in the day because of the issue and the agreement that was reached? Essentially, that's why the court ordered 30 hours community service, because of the same victim, same thing that put her on probation before, and she needed to provide to the community and give back. How should the court view that? Because I'm guessing
That's an
now-
aggravating fact. That's aggravating. What's aggravating and what's mitigating on the balance of the scale, I know where that falls. All I can say is she's an addict. It's not a defense. It aggravates the offenses, but it's also mitigating because what addiction does to the brain and the ability to make rational, good decisions. That's the reality we have.
All right, thank you. Mr. Schmidt, I have Mr. Harrington stating that it's 153 days of jail credit. You're stating 98 days. Do you stipulate? Do you contest?
I do not. I stipulate. I believe Mr. Harrington is referring to time in Minnesota. One of the jails he believes counts towards it. The DOC packet doesn't talk about that. What I would suggest is the court ordering the 98 today, and then Attorney Harrington could give me like where she was placed and when, and then I could call the jail and be like, 'cause my concern is this, I think she might have been serving a sentence she was sentenced on in Minnesota. I'd want to check that.
And with regards to 97 versus 98, are you counting today? Because you would not count.
I did count
today.
today.
You
That's
did
probably the
not?
difference.
And I didn't add, quite honestly, I didn't go day.
Mr. Schmidt's counting today, I was not. So it's,
So
my counting is
97 days.
97.
So it's 97 days jail credit if or until the court hears otherwise as it relates to the time she served in Olmsted County in the Minnesota matter. All right, Ms. Simmons, do you care to make any statement here today?
Like I said, I'm not really good with this. I have messed up. I definitely own up to that. I'm alcoholic really bad, and he was right when he said I'm caring, I'm funny, and I'm a good mom when I'm sober. You know, my life has been a little chaotic, and I wanted to get it back together, and also my health is not the best right now. So I'm supposed to see a cardiologist, but I can't because I'm incarcerated. So I'm really worried about that as well. I don't know what else to say. I'm sorry.
Thank you. Ms. Simmons, I remember your case, quite honestly, very vividly and very clearly. And when I saw that you were back in custody, I'm like, oh, I haven't seen Nicole in a long time. And this is why, because immediately when you were placed on probation for this case, you absconded and you disappeared. You ran, quite honestly. You didn't do what you had promised to do, because this was a negotiation. And it did take your attorney and the state to negotiate and and come from the felony down to the misdemeanor. And was for all of the good and positive reasons. And it was, the victim did make a statement back then, which was impactful. And she did again here today, that in part, it had to do with the negotiating down from a felony to a misdemeanor, was in part because the victim did say, you have always been a close part of her family, her life, and you essentially stabbed her in the back. Addiction does take over, and addiction is a demon. It really is. But it doesn't excuse the behavior, and it doesn't excuse stealing and taking and destroying the people who have always been there for you. And that would be Miss Ekstrom. She has been a part of your life, essentially your whole life. And then you, instead of, how did you repay her? Not in a positive way, with negativity, and you continue to take and take and take from her. And so you had the benefit back then of having it amended from a felony down to the misdemeanor. And then you had said, I'm going to do what's right. I'm going to do what's right. I remember this vividly. I remember it so clearly that you said, I'm going to pay her back. I'm going to show her that I didn't want to do this. But you didn't. Within a month or two, you were gone, and you didn't pay your restitution. You didn't give back to the community, as you said, and do the community service. You didn't do the services or go to probation. You didn't seek out treatment. You didn't try and do anything to better yourself and your life and your children's lives. When you are sober, I fully believe you are a good mom, a dedicated mom. But for the most part, you're not there. Your children don't have the gift of having their mother be present in their life, because when you are high, when you are drunk, when you are under the influence, you are not really present. Your body may be there, your heart, your mind, your soul is not. And your children know that. And so every time you've been choosing the drugs, the alcohol, the crimes, the things, you've been choosing that over your children. You've been choosing that over yourself. And I think you need time to sober up and get clean. And you need time to be punished because you ran. And but for the fact that this was amended from a felony to a misdemeanor, and this is the only but for that fact, your butt would have been back here in this chair a whole heck of a long time ago. But you were given the grace of the misdemeanor. And so I cannot extradite you back here to Wisconsin. So you knew that. You knew that a misdemeanor couldn't come back. And I'm going to say you know it because you've been in the system, and you've been in the system a long time. So you kept evading responsibility and accountability for this case. And all of that comes back in to play now for the sentencing portion. And that's essentially why withheld sentences sometimes bite worse than if the court were to originally have sentenced you with either an imposed and stayed, or sentenced you to jail up front. Because here, now, with the facts that I have them laid out, and with the facts as they were back when you entered your plea, this is a maximum possible penalty. And so I am going to sentence you to 9 months of incarceration with 97 days of jail credit, which I will review if there's any reason to adjust it upward. But even still, it's not going to go extensively upward or significantly more upward, but 98 days of jail credit. I believe the court is going to enter a civil judgment against you for the restitution. You're always going to owe that. I mean, you could sit additional jail if we have to continue to come back after you to pay, because the court is going to order that with regards to the civil judgment, you have to pay $300 a month once you're released. You have the ability to work. You have to pay for yourself and your bills and the things that you owe, and this is one of the things that you owe. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that we've covered everything. Mr. Schmidt.
Nothing from me.
Nothing except, Mr. Schmidt, are you gonna call Olmsted County?
I've got 45 minutes after this. I was gonna ask what dates and just do it right now.
All right, we'll take care of that, but, no, I do not.
All right,
anymore. Thank you, Judge.
thank you.